On behalf of Baker McKenzie and the IMT Group, welcome and thank you for joining today's webinar, Asia Pacific IMT webinar series, Customs Audits and Export Controls in China. My name is Yaeko Hodaka, and I'm the co-chair of the Asia Pacific Industrials, Manufacturing and Transportation Industry Group of Baker McKenzie, based in Tokyo. Customs issues are something very important, but at the same time, somewhat unpredictable, especially in Asia countries. Not a few companies with a big presence in this region get into trouble with customs authorities, and this trend has been worsened by the fact that the governments are financially struggling because of the pandemic. We see such cases, especially in Southeast Asia, but how is the situation in China? As you notice, today's session will focus on China. I'm pleased to be joined by my colleagues, Tina Lee from Fenton Partners, a joint operation office with Baker McKenzie in Shanghai, and Wen Kyung Kok from our Baker McKenzie Hong Kong office. Tina's practice involves a wide range of legal services in international trade and commerce, including advising on tax and customs issues and other PLC regulatory in relation to supply chain optimization, export controls, trade compliance, and customs dispute resolution. Wen is an associate at the firm's International Commercial and Trade Practice Group, focusing on sanctions and export controls, customs, rules of origin, valuation, indirect tax, FTAs, WTO rules, and product regulatory compliance. And now I will hand over to Tina, who will kick us off with today's presentation. Thank you, Tina.
Thank you, Yuko. So let's move on to the next slide. Thank you for continuing the China session. So in this first part, I will take about 30 minutes to cover the key topics regarding customs audits in China, including what the hot topics has been. So without further ado, let's move on to the next slides to take an overview of what are the customs disputes. So customs disputes are the matters that involve non-compliance with the China customs laws and regulations, including a customs audit procedure. So in these cases, China customs seek enforcement on those non-compliance issues and can impose penalties. Both can be a civil or criminal penalties ranging from warning, fine, or imprisonment. So in these cases, the client would approach us for professional support to help with the legal analysis and also the matter management negotiation with the China customs. So on the next slides, we can have a look at the what is the different organization chart of the customs levels in China. So on the top, we have the General Administration of Customs, or the GAC, which is directly subordinate to the State Council, the central government. And below that, there is the city level customs. For example, Shanghai Customs, Nanjing Customs, etc. And down at the bottom, there will be the port customs or the customs at the local level. And those are the customs that companies operating in China that they deal with most during their daily operations. So besides that, I would like to highlight that starting from 2017, as a result of the customs organization reform, the GAC set up 3 branches in Beijing, Tianjin, Shanghai, and Guangzhou, respectively. So the GAC branches lead the risk-based approach in managing the customs matters, the customs disputes over the country. So on the next slides, we have a overview of what are the hot topics, the areas where customs disputes can arise from. So the first and the critical important topic is regarding the customs valuation. So customs valuation is one of the most important elements for customs to assess the duty amount. So in this area, customs would review whether the duty, whether the value, the import price declared at customs satisfy the China customs valuation rules. So for example, the customs can review whether the transfer pricing between the companies can be accepted as a transaction value for customs to assess duty. or customs may take a review of whether they have in place any royalties that should be added into the import price of the goods in order to levy tax. The other area of topics that disputes can arise is the classification of the goods being imported or exported out of China, or the tariff code. So tariff code is very important because it determines what is the applicable duty rate. And also, it is also important because China customs may sometimes refer to these tariff code in determine whether to enforce a import or export license. This is the area where disputes commonly arise from. And the other topic is what is the country of origin of the goods being imported into China? So if you are importing goods from a country that is a trade partner with China, having in place a free trade agreement, there is a chance that you can claim for the preferential duty rate. So customs would also review whether the origin of the goods declared to them is accurate and in compliance with the relevant rules and regulations. So in addition to the big three topics that we just covered, which are the most three important elements in determining what is the amount of the duty rate, and another area is the bonded processing. So China has in place this bonded processing regime where to allow companies, they can import materials on a bonded basis if the products that manufactured in China would be ultimately exported out of China. So under this regime, the customs would take the focus of the customs can be whether the company has mixed the bonded materials with those non-bonded materials, and also if the products that ultimately manufactured in China, if they are sold just within China without being exported out of China, whether the company has obtained proper approval and settled the duties and taxes before they perform the domestic sale. So these are the common topics or areas where China customs would focus on. So with that, on the next slides, we take a look about what can the consequences be if there is a customs dispute arise. As a result, if China customs find that there is a non-compliance, the consequences can be if it determines to be a simple breach of the customs administrative regulations. China customs can impose penalties, including warning or fine. And more serious if China customs discover that there is an intent on the company or the person, there is intent to evade tax, or there is intent to avoid licensing requirement or other customs supervisions, and the case can be escalated to a criminal case, to a smuggling case. And if, depending on the severeness of the case, it can be further escalated to a criminal smuggling charge. So there can also be the case where after the investigation, customs determines that even though there is no compliance committed by the company or the person, but because of certain action, there is an underpayment of duty. Even though as a result, the customs cannot impose penalties, but it can still claw back the underpaid duties following the investigation. So on the next slides, we touch upon whether there is any potential waivers if a penalty can be imposed. So according to the administrative penalty law, if the violation is just minor and the company has already taken remedial measures in time without no harmful consequence cost, it should be the penalty should be waived. So this is a statutory waiver. And also the topic that we always hear is about whether the company make a voluntary disclosure to customs. So making a voluntary disclosure to customs is always considered as a factor to mitigate the penalties assessed. And in this regard, China Customs issued a regulation in the year of 2019 to encourage companies to perform self-assessment and encourage them to make voluntary disclosures if they identify the breach with the customs regulations. So according to this new regulation, so if you identify some non-compliance, if you make the voluntary disclosure within 3 months after this violating act, and also you take the actions to corrective actions to eliminate the harmful consequence, if that is the case, the penalty can be waived. And if the disclosure is made after the 3-month window, there is also a threshold that if the underpaid duty is below certain threshold, certain dollar amount, you still can be granted this waiver. And under either situation, as long as you make the voluntary disclosure, and if the ultimate penalty assessed by China Customs is less than 500,000 RMB, even though the penalty will be ultimately imposed, it would not be taken account to impact your company credit rating. So this is very important because penalties imposed on a company can impact their credit rating, and the credit rating can impact for example, the inspection rate, the speed of the customs clearance speed. So this is worth noting. And also we just want to highlight that this whole regime, the statutory waiver, only applies to the breach of administrative regulations that result in the underpayment of tax. So if your breach result in, for example, mis-submission of a license, a certificate or import license, or if it is a smuggling case, such waiver is not does not apply. But still, in any cases, voluntary disclosure is still considered as a factor that can help mitigate the penalties to be assessed. So those are the quick overview of what are the customs disputes and the customs audits in China. So let's move on to the next session to talk about more technical aspects in area of customs audit. So in this subsession, we share observation about what has been the focus of China Customs in the China Customs audit cases. So as I just said, customs valuation is an important area that China Customs would focus on. And in the past, especially prior to the year of 2021, so when customs looking at the different companies on their customs valuations, on trading companies, China Customs generally only focus on whether the transfer price between the related generally, the focus is on whether the transfer price between the related parties they are within the arm's length, they need to be adjusted. And for the manufacturing companies, China Customs would focus on whether there are any royalty payments that need to be added into the import price of the goods. But since 2021, the focus of China Customs kind of expand. So for the trading companies, the China Customs not only review the TP, but we also see cases where they would move and focus on if there is any royalty payment. So we have several clients that they have in place the royalty payment, which have never been challenged by the customs, but just all of a sudden be queried by customs to understand whether the royalty payments satisfy the conditions to be added into the duty value of the imported goods. And also following the similar trend for the manufacturing companies, the China Customs would also take a review of the transfer pricing if the manufacturer imports material from related suppliers. So they kind of expand the review scope and take a more comprehensive approach when reviewing the customs valuation issues on different types of companies. So on the next slides, we briefly touch upon the what are the common triggers that your customs valuation issue can be identified by China customs. So these include if you are importing goods, but all of a sudden you make a significant adjustment to the price itself. So such adjustment can be captured by the customs system and give them alert to see whether there's the adjustment is justifiable, and also customs may therefore review the transfer pricing, the transaction value of the imported goods. Similarly, if a company suddenly makes a outbound payment of royalty in a huge amount, so because China exercise foreign exchange controls, so this payment information captured by the foreign exchange regulator, they can pass this information to the China customs, which can further assign the case to, for example, a local customs level to perform further inquiry or investigation over such payment to see whether they satisfy the conditions to be added into the customs value. And also, because on the China declaration form, if you for the first time have in place a royalty payment and that satisfy the condition to be added into the customs value, and because of a reporting requirement, you need to check the box on the import declaration form to indicate that there is such an arrangement in place. So if it is for the first time that you check the box, so this can also be alert to China customs to perform further inquiries or an audit to see whether the royalty payments should be added into the customs value. So the next example can be further illustrated on the next slides. So here we show you an example of how customs would view the addition of the having in place a new royalty arrangement. So if a company decided to have in place a new royalty arrangement, and after the analysis, this royalty satisfy the condition to be added into the customs value. So prior to this arrangement, your import price is just on the left column, the light right part. But after you impose an additional royalty part, from the customs perspective, the dutiable value of your product is increased. So this will be alerted by customs to consider whether the price in the past import, are they sufficient, and they need to be adjusted so that additional duties need to be paid. So that is the logic. Customs can bring questions to the importers if customs notify that there is a new royalty arrangement in place. So similarly, we have seen clients that they may sometimes adopt the so-called variable royalty arrangement. So under this type of arrangement, the royalty payment is associated with whether there is a operating margin. Well, how much is the operating margin throughout a year? So as a result, you may pay royalty for a certain year, but not pay royalty on the other years. So this will also be questioned by customs, because the dutiable value from the perspective of customs varies from year to year. So this can also trigger their attention to see what exactly the import price should be. So on this, so this is the royalty issue, and on the next slides we can quickly share how China customs TP planning can trigger customs queries. So there are, for multinational companies operating in China, for purpose of tax compliance, they may need to adjust their TP at the year end in order to achieve certain operating margin. So if for a year they need to true down the operating margin, for them the option may be they need to increase the import price of the goods. But in China, at least as of today, China does not have in place a formal or meaningful mechanism for the companies to do that. So a little bit background, because China exercised the foreign exchange controls. So if you want to adjust your import price and pay the difference out of China, each payment for trading goods must be supported by the correspondent customs declaration forms. So because you declaration form have been already submitted with the lower price, in order for you to pay the difference out, you need to adjust the customs declaration form. But I just said there is no formal procedures currently for Chinese companies to do so. The only exception is that, let's move on to the next slide. So the only exception is that in Shenzhen, China has started to adopt a pilot program to allow the cities operating in, to allow the companies operating in Shenzhen, if they have in place an advanced pricing agreement with the tax authority, they can approach both tax authority and customs to discuss an aligned management so that they can make the adjustment to their import price at the year end. But besides that, in the rest of the country, there is still no formal procedures to follow if you would like to make this adjustment. So in practice, what other companies to do is they would just launch the ad hoc negotiations with China customs. So the problem is that because there is no unified procedure, so such negotiation need to be performed on a case-by-case basis. And also, as a practical matter, once this negotiation is kicked off, you need to bring the same topic to customs each and every year. So this negotiation, once launched, need to be performed on a yearly basis. So on the next slides, we share the key consideration and the suggestions that we gave companies when they are making decisions regarding their transfer pricing and transfer pricing planning. So before you implement a new transfer pricing policy, or you make any adjustment, any decisions on whether to make the transfer pricing adjustment in China, just be mindful that there can be potential China customs implication. So it is encouraged that companies should perform analysis on what the customs implications can be before they make each and every decision. So if an adjustment is required, so under the current China customs regulation regime, still, if you want to make the adjustment, incremental and prospective change is still the preferable option. But if you nevertheless really need to approach customs and make this ad hoc adjustment, so it is suggested that before you proactively approach China customs, you should perform analysis on the perform the technical analysis on your case, whether you have a strong case to present to the customs before you decide what is the right course of action to take. And also, if you would make the retrospective TP adjustment, just consider the procedures that we mentioned. You need to perform the ad hoc negotiation with China Customs. And also, once this top dialogue is open, you may need to undergo the same process each and every year. So with this niche topics covered, let's move on to a broader concept about what the more general advice in how we should handle customs disputes. So on the next slide, we list out several common mistakes companies that can have when they manage their customs disputes. The first one is they didn't have enough planning how the procedure should be led, how the case should be proceeded. And also there can also be possible that some companies, they just have little control over the dispute process. For example, if the process is only handled by the operation or the business team without supervising by the legal or compliance team. And also in some cases that the companies may agree to accept the so-called independent agent's assistant. And we also see some companies that they just have overly reliance on the customs brokers or their import agent to handle their customs dispute cases. On the next slides, we give you some tips on how we should manage these custom disputes. So the first and very important tip is that we need to have both the internal and external communication protocols to control how the messages should be conveyed both internally or to the outside counsels, to the customs officials. And also a very important factor is that we should understand our case. What are the facts, whether there is any arguments, whether there is any defense, whether we have a solid technical basis for the dispute that we currently have with the China customs. And also during the dispute process, we need to navigate what exactly is the customs demand, what is their request, what is the focus of this audit case, and also we should manage the negotiations with the China customs. And more importantly, whenever there is a dispute, remember to take some corrective actions. And I just mentioned in the prior slides that taking corrective actions can be considered as a mitigating factor when customs assessing the penalties. So on the next slides, this lists out the spots where the companies can see where the disputes may arise, to kind of give you alert about when the issues can be anticipated. For example, if your goods are stuck or held at customs, it is possible that a potential non-compliance issue may be identified by the customs. And also if you receive certain notice from the China customs, such as a new notice of price inquiry, or you receive a notice that there is a audit or investigation going over your company. So this can be the alert. And also China customs may pay random visits to the companies because as China customs has the authority to perform the so-called random audits as a routine work. And also if sometimes even without a formal notice or notice letter or formal notice, customs may approach companies to, for example, to perform some survey, or just give you a call to request for certain information to understand the operation of your company. This can also be the case. And also, last but not least, just be mindful of the whistleblowers who can report the non-compliance issues to the customs. So with the above, I would like to move the control to my friend and colleague Wayne to share more about the a move from the import side to the export side and talk more about the export control updates in China. Here you go, Wayne.
Thanks so much, Tina. I do think that audits and customs audits are some of the most stressful and challenging, issues that in-house professionals have to navigate. So I think, Tina, thanks so much for taking us all through of that today. If we are, adjusting import prices, or if I am, checking that magical royalty paid customs box on the declaration form, I will definitely make sure to call you first before I make any of those decisions. But yes, like you said, we're moving now from inbound all the way to outbound. So firstly, talking about imports into China. Now we're talking about exports from China, and really some of the regulatory developments on that front. So if we could move on to our next slide. So maybe just a refresher or level set for some of our audience members who might not be too familiar with export controls. So China has had an export control law since 1st December 2020. That's the formal export control law. And these are some of the key concepts under that law, whereby we have control items, whereby these are generally dual use items, where items have a dual military as well as civilian purposes. And they include military, nuclear, technology, services that relate to the fulfillment of international obligations, and encryption items that is an especially significant some of a category of items that a lot of our clients do have to navigate. We have deemed export controls as well. So if I were in Shanghai, talking to Tina, and I'm a non-Chinese national, and if Tina was transferring some control item to me, notwithstanding the fact that I am in Shanghai, and I'm not necessarily exporting. Tina is not necessarily exporting outside of Shanghai, outside of mainland China. That could be still considered a deemed export. We have catch-all provisions relating to national security, WMD, and terrorist activities. Licensing considerations. So these are the key items that you have to pay attention to if you are exporting a control item from China. These are the type of considerations that authorities will consider before deciding whether to grant you a license. International obligations, national security, that is at the top of regulators' minds a lot. The type of export, the sensitivity of the item, the destination, the end use and the end user of the item, the credit record of the exporter, and one more catch-all, other factors provided under law. So these are licensing considerations one have to think about. Prohibitions and temporary measures. We have a dual use list, a controlled dual use list, but apart from that, there might be temporary measures and temporary controls on other items. We have blacklisting control on sort of blacklisted end users and importers. So this would be outside of China, persons outside of China who might not be able to receive items from China, subject to these blacklisting controls. And of course, compliance professionals, we have to pay attention to this internal compliance programs for the running of to ensure compliance across the business with export control laws. And we'll speak a bit more about that after. So this is the key framework for China's export control law. If we move on to the next slide, I think we'll talk about some of, Iris, if we could move on to the next slide. We will talk about some of the recent developments with the draft export control regulation. So like I mentioned earlier, we had a new export control law sometime in 2020. Since that has become effective, MOFCOM has recently just, in April 2022, released these regulations on dual use export controls for public comment. So at this stage, these regulations are very much in draft form. And they were for public comment from April to May 2022. So the time for public comment has lapsed. But I do very much think that these draft regulations, they do give us sort of an indication of the type of how regulatory control in respect of dual use items could develop in China in the years ahead. So firstly, the scope of control, like I mentioned earlier, although the draft regulations, they do focus on dual use items, they also include a provision that allow the regulators to apply rules of the export of non-dual use items controlled by China, where the relevant regulations leave gaps to be filled. And so this could include the export of technologies that are currently regulated under a separate legacy technology import and export control regime, which sits alongside the export control law. And of course, this also regulates, this could also lead to controls on other items that are not on either of these regimes. So that's scope of control. If we could move on to the next slide, classification and destination-based controls. So currently, MOFCOM and Customs, they publish and update a consolidated dual use list on an annual basis. This is usually towards the end of the year. And these are really based on technical descriptions. Firstly, I think technical descriptions describe each of the items that are subject to dual use control. They also provide accompanying tariff classification codes. And these are Chinese PRC tariff classification codes up to the 10-digit level. So this would be indicative of control. So what is new with these draft regulations? What do they bring more than the current position? What the draft regulations contain is that there's a reference to establishment of an export control classification code. So perhaps, apart from just the 10-digit tariff classification for under this list and the technical descriptions, we might see a new regime of China ECCNs under the draft regulations. And there might also be this country of destination risk grading system. So currently this is not in place. The sort of licensing considerations that go into whether to approve the export that is not expressly rolled out in regulation, but perhaps we might see country of destination based response rules. And this approach, of course, aligns more with international export control regimes that some of us might be more familiar with in other jurisdictions. If we could move to the next slide. Prohibition to accept investigations by foreign authorities. So this is an express provision in the draft regulations. They specifically prohibit Chinese individuals and companies from cooperating or committing to cooperate with agents of foreign governments on on-site export control interviews or investigations. So certain foreign export control authorities, they might conduct investigations, interviews, verifications across the globe. So now under these draft regulations, these sort of cooperation with these interviews are prohibited unless there is MOFCOM approval. And currently it's unclear as yet how MOFCOM approval could be obtained and how such restriction might impact compliance and ability to secure export permits under foreign export control regimes. If we could move to the next slide, the general licensing regime. Under the draft regulations, they provide for two licensing options: specific licenses and general licenses. So specific licenses are for specific exports to regarding a specific item to a specified end user. So it's a more narrow license, whereas general licenses could be issued to the export for the export of multiple end users with respect to many items within a period of 2 years. So of course, general licensing would be more conducive to businesses with operations which are more repetitive in nature. If you're always exporting something consistently, every week, that there are shipments going out of Shenzhen or Shanghai, then a general license might be more helpful for your operations, whereas a specific license might be more helpful for just a one-time ad hoc export of a control item. And if you do want a general license, then an internal compliance program that would be helpful towards securing such a general license. And if we could move on, thank you. License exception. So this is where I think businesses can sort of clap their hands and rejoice a little bit, because if we're always faced with the requirements to apply for licenses, then that would increase the operational lead time for our shipments. We will need to make sure that we factor enough time to apply for licenses, get the regulator to approve them, review them, approve them, and have them on hand before we export. But with license exceptions, that could reduce the need for such lead time, and we can just ship. But they are confined under these draft regulations. They are confined towards specific categories. So re-export of goods brought into China for maintenance, testing, or inspection, and it has to be back to the country of export and within a reasonable period of time. Re-export of goods brought into China for the purposes of exhibitions in China. Civil aircraft, so that is a specific category, and it has to be civil aircraft parts and components for maintenance purposes. So, people in the aviation industry rejoice. And finally, other circumstances which might be prescribed. So I think we have an indication that perhaps moving forward, there might be other license exceptions available. But note that it's not just, you can't just get, it's not a free for all. You will have to, under the draft regulations, you will have to register with MOFCOM before you export. So it's not a sell. So perhaps no need for a full-blown license application process, but a need for registration at this stage. If we could move to the next slide. Thank you. End use controls, where there's a change in the end use of an exported item, then the obligation is placed on the foreign end user to apply to MOFCOM for change of end use of the goods. So if This really applies to persons outside of the China. If you want to change the end use of an item that has been exported from China, you have to apply to MOFCOM to change it. You can do so through the Chinese exporter. I think that might be more convenient for just for logistical purposes. Catch-all controls, I think this is not unfamiliar to anyone who use of export controls. Your compliance program must pick up, sort of the items that are not subject to dual use controls, but if they are contributing towards WMD, weapons of mass destruction risk, or risk of terrorism, risk of national security and interest, then these items are still subject to controls. What the draft regulations sort of introduce is this obligation for the foreign importer for a period of 3 years after the date of exportation, if they realize that there has been a risk of these categories items occurring, then they will have to make obligations. They will have the obligation to report the same to MOFCOM as well. So that's catch-all controls. Blacklisting, I think this is also not unfamiliar to a lot of us who have been sitting through a barrage of trade war measures in the past few years. So on the export control law level, it authorizes the Chinese government to prohibit export of goods, technologies, or services to designated countries, entities, or individuals. So no designation has been made under the Chinese export control law to date, but what we are now seeing is the draft regulations providing more specific provisions for importer or end user blacklisting. And they provide that, there might be denial of general licenses and license exceptions where the item is exporting to where the item is being exported to any blacklisted importer or end user. And also, I think this is most helpful. It's not an end game. If any foreign person is subject to blacklisting, there are delisting procedures, and so there is an avenue for being delisted from such a blacklist. If we could move to the next slide. Third-party responsibilities. I think the supply chain is long and it is complicated, and it has many parties acting together to maintain operational efficiency. Not only the exporter is liable or obligated, other parties in the supply chain, they are also responsible for maintaining compliance with export control laws. So under the draft regulations, upon discovery of any exporter engaging in export control violations, third-party persons or companies engaged in the provision of agency, freight, delivery, customs declaration, third-party e-commerce trading platforms, financial services, they must immediately cease their activities and report the same to MOFCOM. And so these would be, brokers, agents, forwarders, e-commerce platforms, financial service providers. Everyone has a part to play in maintaining compliance with the export control requirements. Next slide. Multi-agency collaboration, and this is a multi-agency regulatory regime. And I think this is consistent with, with other export control jurisdictions that we see across the world. It's not just one agency that is overseeing export controls. There are multiple agencies looking after export controls. The draft regulations here, which is slated to be issued by the State Council, China's cabinet, once formally adopted, will put in place a mechanism for MOFCOM to work with other government agencies in enforcement. So these might be agencies in charge of public security, national security, financial regulation, market regulation, customs, and public transportation. Now on to internal compliance guidelines on the export of dual-use items. I think this is for compliance professionals and geeks. If you want to nerd out and have sort of ensure that your own company's compliance policy complies with the guidelines, then we can sort of go through the 9 key elements that MOFCOM's guidelines requires. Firstly, enactment of a policy statement. I think this is important because it kind of signifies from a top-down approach that the policy is important. It's not just a document to be drafted and filed away in the cabinet and on the office intranet, and nobody sees it or refers to it. after its approval, it's something that's important and has to be taken seriously by all corners of the company and of the business. So the policy statement is first and foremost important. Organizational structure to delineate responsibilities of different parties within the organization for adhering to the policy. Risk assessments of different types of exports. If you're just exporting to a regular customer, that you have done all your general KYC and AML requirements, and you've been transacting with them for a long time. They're not subject to any sanctions or listing requirements. Then perhaps this is a lower risk sort of export. If it's a new customer you haven't met before, you haven't done any KYC, you haven't done any AML checks, then perhaps this is higher on your risk assessment rating. Review procedures, that's important. Formulation of emergency measures, trying to understand what you have to do in uncertain situations. Training and education, keeping your employees and members of your team up to date with export control requirements. Compliance audits, so persons doing your own audits on your operations and your exports, not just I think this is a very important part of any compliance strategy, because you really want to know where are the gaps in your own platform before you potentially have to open your books or your situation to the regulators and have them discover your gaps before you do. That is always something that is very stressful, and you won't want that to happen. So conducting your own audits before the regulator audits you, that would be helpful. Record keeping requirements, so generally a couple of years to ensure that all your books are in order and that they are readily available and easily accessible. Management manual preparation, so having a readily accessible management manual for all types of persons to access and understand what the requirements of the policy are. So yeah, these are the key elements of an ICP. These were subject to a separate this was a separate under separate MOFCOM guidelines that were released earlier. What the draft regulations today sort of introduce is that, firstly, like I mentioned, if you have an ICP, then it might be easier to get a general license, for example. It also encourages the exporters to accord certain benefits. For example, penalty mitigation in cases of violations and whatnot. So, but I mean, apart from just privileges, which you may or may not require, I think having a compliance program for export control is always helpful, because you know that you are on firmer ground when approaching these complex issues. And if the situation changes and enforcement, the rules change, the regime tweaks its requirements, or enforcement with regards to export controls increases, then we might see then having a compliance policy that's already executed on the ground will be more helpful towards building a culture of compliance for new export control requirements. And if we could move to our next slide. And yes, I think now we move on to questions. Thanks so much for everyone posing questions onto our platform. If I could just read out the first question, and I think our first question would be on customs audit issues. Tina, if you could let us know how do we determine whether voluntary disclosures could be pursued? Are there any recommended considerations for the pursuit of voluntary disclosures?
Sure. Thank you, Wan. I think to answer this question, it is so I guess the question is about when you identify an issue, customs potential non-compliance issue, whether we should determine to make the voluntary disclosure or remain status quo. So to answer this question, the key message is that you need to perform analysis to understand what exactly is your case, to understand your case, to see whether it's a true compliance issue, or there is any legally viable defense argument that we can argue is not a non-compliance. And also we need to analysis in addition to whether we have a strong technical basis for that case. We need to analysis what if this is ultimately penalized by customs, what the potential consequences can be. So as I just introduced in the prior session, that China customs has a regime that allows certain circumstances that if you make a voluntary disclosure, the penalty can be waived. So after you make all the assessment that I just mentioned, including what exactly is the potential consequences, how big is the penalty that can be imposed, you can verify and determine whether making a voluntary disclosure would warrant a waiver to the penalties or not. So with all that said, I would suggest the key step to take before making that decision is to understand the case and analyze your case.
Thanks so much. Thanks so much, Tina. Another question from the audience: what is the possibility that China will adopt a US ECCN classification approach? And any suggestion on how we should perform such classifications? So I guess, like I mentioned earlier, the draft regulations at this stage, they do propose the possibility of the introduction of export control classification numbers. It doesn't state that this will be US, ECCN classification numbers. It's still open-ended at this stage about what classification numbers these will be. And secondly, of course, these regulations are in draft stage. So if they are in draft, we don't know whether they will be eventually implemented into law or not. And of course, at the end of the day, when we look at how China controls its list of items, it's really the dual use list, whereby the items, firstly, the technical descriptors are paramount. The technical descriptions are paramount in deciding whether an item is subject to control or not. So you will have to classify your list of inventory, your list of goods according to the technical descriptions. Secondly, the Chinese HS code, tariff code at the 10-digit level is indicative of control. And so, you can't just rely on overseas tariff classifications. You have to do a PRC HS tariff classification analysis on all your items, because tariff classifications could differ from jurisdiction to jurisdiction. The WCO only harmonizes the tariff codes at the 6-digit level. So further tariff classification has to be done. And so I think at the end of the day, you will have to, given the divergence between international export control regimes and the Chinese dual use goods list currently, a separate sort of system for classification will have to be done to maintain control over Chinese dual use items. That being said, the encryption items list currently aligns with the Wasana list. So that is one area of comfort for compliance, because we can rely on classifications on that front to understand what items in China are subject to control, and if not, but for all other items, I think a Chinese-based classification regime must be implemented. And I think we have another question on a similar item, on a similar matter. In case customs questions whether an item is subject to China export control law, what is the document that could be used to justify that the item is no license required from a Chinese export control law perspective? And if the document is required from MOFCOM to justify no license required, then that might be burdensome or difficult for businesses. So like I mentioned earlier, for China export controls, the dual use list technical descriptors is really paramount. So if you want to demonstrate that your item is not subject to any of these technical descriptors, a technical classification analysis showing why the item does not fall under any of the relevant technical descriptors, that would be extremely helpful to justify to regulators that hey, my item is not subject to export control. And then of course, because the PRC tariff schedule is also indicative of control, if you can show apart from just technical descriptors, not falling under technical descriptors, if you can also show that at the 10-digit level, your item does not align with the 10-digit level controls, then that will also be helpful to justify that the item is no license required. And now we are moving on to another question. And this is perhaps a question for Tina. The question is, with regard to royalties, we understand that the Chinese customs sometimes requires to disclose a composition/breakdown of import price in order to examine whether royalties are included or not. Is this understanding correct?
Sure, thank you, Wayne. Yeah, actually, if it is when China customs looking at the import price itself, generally they will not examine whether there is a royalty built into the import price. But on the other hand, there are cases where China customs, when they see there is a separate payment of royalties, which generally arise when you have when China customs see a separate payment of royalties, they may review such payment and consider whether this royalty payment satisfy the condition to be added into the import price of the goods. So in this type of review, the dispute would be regard what exactly is the coverage of the royalty, what is the IP licensed, whether these IPs are within the scope of the royalty payment, whether they are, which portion is related to the import goods. So it is more from this angle. But this type of analysis can involve very highly complex factual analysis, and it can involve highly technical complexity. Sure. I think, yeah, thank you, Wayne. I think we don't have further questions there. So let's just, I will pass the control back to Yoko for the closing.
Okay, thank you very much, Tina and Wen. On behalf of Baker McKenzie and the IMT group, thank you for joining today's webinar. We would appreciate your feedback through a short survey. Just click on the link that will appear as you close the window. And please join me in thanking our speakers, Tina and Wen, for an excellent discussion on China, the updates and developments. We hope that you found this session informative and relevant for your company's operations. For more information, or if you want to discuss further, please do reach out to Tina or Wen. The next session in the series will focus on Indonesia that will take place in July. We look forward to having you there. Goodbye for now and have a great rest of the day ahead. Thank you very much again. Bye-bye.